Hello everyone, welcome to IMS Get Set Law channel. I'm Akash Srivastava, your law mentor, and today in Law Library session, I'm going to discuss a very important and interesting judgment. The name of the judgment, as you can see on my screen, is Donoghue versus Stevenson. So students, before we discuss the facts of the case and the judgment, it is important to know why this case is so important in law of tort. So this is important because in this case, court explained the correct meaning of negligence, duty of care, and explained the true meaning of neighbor. So students, let's start and discuss the case. So what happened? First of all, we are going to discuss the facts of the case and then we will move to the judgment. So Mrs. May Donoghue and her friend went to a cafe where she ordered a Scotsman ice cream float made of ice cream and ginger beer. Then when she drank ginger beer, there was a snail in decomposed state. Okay? Then what happened? When she saw the bottle, there was a label of D. Stevenson Lane Paisley. According to the appellant, in such circumstance and consequence of the impurities in the ginger beer, where she already consumed that, she suffered from shock and severe gastroenteritis. When we talk about these types of cases, what exactly happens? It depends upon the sale. So if there is a contract of sale, it is totally dependent on that. But in this case, what happened? There was no contract of sale between the manufacturer and the person who is consuming it. So while normally the remedy sought out for the defensive product would be brought under a contract of sale. However, no such relationship existed between Donoghue and Stevenson, the manufacturer of the ginger beer, and the person who consumed it. Therefore, she could only obtain a remedy to bring an action for damages for the manufacturer's negligence, because this is the only route through which she can get the remedy. She will have to file a case where she will claim damages for the manufacturer's negligence. So what happened after that? The appellant instituted the proceedings against the manufacturer and a writ was issued against David Stevenson by Donoghue's solicitor, claiming 500 euros as damages and 50 euros as cost. So I will explain the whole facts again. So what exactly happened? There was a lady, she went to a cafe, ordered a ginger beer, and there was decomposed snail. And after drinking that, she said that she suffered from shock and severe gastroenteritis. Now she wants to file a case, she wants to get the damages from the manufacturer. But as there was no contract of sale between the consumer who is consuming the goods and the manufacturer, so she will have to file a case of negligence. That's why she filed a case and claimed for 500 euros as damages. So students, this was the facts of the case. Now let's discuss the judgment and let's discuss what were the arguments framed by both the parties. So first of all, Donoghue argued that Stevenson owed a duty of care to his consumers or customers who were to consume his ginger beer, to have an effective system to clean his bottle and keep it away from snails. This is what the primary argument was, that if you are manufacturing something, then you have a duty towards your consumers or the customers who are going to purchase that. And the basic duty will be to clean the bottle and keep it away from snails. This breach of duty is alleged to have caused Donoghue's subsequent illness, and due to that, as Stevenson was supposed to take care of these two things, to keep his bottle clean and keep away from snail, and as he failed to do that, this was the sole reason for Donoghue's subsequent illness. This was the primary argument framed by Donoghue. In response, Stevenson said that Stevenson denied having snails in any of his bottles. He said कि मेरे यहाँ तो किसी bottle में snails है ही नहीं, arguing that Donoghue's health problems have been caused by her bad health condition. So he said that this is not the bad health condition of Donoghue is not due to ginger beer. It is because of her bad health condition. He stated that the facts were not proved. He did not cause Donoghue any harm and that the damages claimed were excessive. He said that whatever happened to Donoghue, this is not because of me and she cannot claim any damage, and whatever damage she is claiming, that is too excessive. So students, these were the two arguments, one from Donoghue's side and the other from Stevenson's side. Now we will have to see what court observed. The court had observed that when a manufacturer puts out an article in the market intended for human consumption in a form that precludes the possibility of an examination for the report by the retailer or the consumer, he is liable to the consumer for not taking reasonable care to see that the article is not injurious to health. So court is trying to say that whenever you are manufacturing anything, if you are putting that in market, then it's your responsibility that if it cannot be examined by the consumer or the retailer, they cannot see what exactly is inside the beer bottle. So you have the responsibility to take care of it. So in this case, the respondent owed a duty to the appellant to take care that the ginger beer had he manufactured, labeled, bottled and sealed, and invited the appellant to buy contained nothing that would cause her injury. So this is the sole responsibility of the manufacturer, that if you are making something, if you are putting that thing in the market, then it's your responsibility to cross-check, to verify that whatever is inside the bottle is not injurious to health. In furtherance to that, Donoghue's counsel argued that Stevenson owed a duty of care independent of contract, because if we talk about law, if there is contract of sale, then only you can file a case. Only then you can claim damages from the manufacturer. But what Donoghue's counsel is claiming or arguing before the court of law, that it is the responsibility is beyond contract and it should be independent of contract, because the bottles in which ginger beers were manufactured could not be examined. You cannot see what exactly is inside the bottle, and also because it was meant for human consumption. So whatever you are manufacturing it, if it is for human consumption and it cannot be seen what exactly is in the bottle, then responsibility lies on you. The House of Lords held in favor of Donoghue. So they said, we agree with you. In response to that, Stevenson's counsel argued that it was an established law in England and Scotland that manufacturers owed no duty to anybody with whom they had no direct contract. This is the law of the land, that if there is no direct contract between two persons, the party cannot sue the other party for the damages. As it happens in this case, the manufacturer and the person who is consuming the goods, there is no direct contract between them. And this is the sole argument that they are trying to prove before the court of law, that we are not liable, because law says that if there is no contract, no liability. Now comes the important part. According to Lord Atkin, the case was important because of the bearing the decision would have on public health. So why they are diverting from the law of the land? The law says that if there is no contract, no liability, but they are saying that what impact will it have on the public? That is why we will have to divert to him the moral rule that requires one to love their neighbor. Now comes the important part that we were discussing, that in this case itself the concept or the ambit of neighbor was discussed. In law manifests as the rule that one has to take care not to injure his neighbor. So this is the sole responsibility of everyone, that you will have to act in such a manner that you should not affect your neighbor. He says that care must be taken, and such care must be reasonable not to put one's neighbor in danger or cause a foreseeable injury. So whatever action you are doing, the consequence of it should not hamper or should not affect your neighbor. He defined a neighbor as one who will be directly affected by one's action or omission. So whatever action I am doing, if anyone, whoever is getting affected by my act, will be termed as neighbor. He may be residing just beside my home. He may be 1 kilometer apart from me, or maybe in another country. If he or she is getting affected by my act, then that particular person will be termed as neighbor. So much that one has to put a person in his contemplation while he does such activity or makes such omission. So whatever act you are doing, you will have to think that what will be the consequence of this act. If the consequence will hamper anyone, that particular person will be termed as your neighbor. The same thing happened in this case also. The manufacturer, while manufacturing, the person who consumed the goods was not his neighbor in the literal sense. But if he is going to consume your goods, if he is going to get affected by your act, then you will have to contemplate, then you will have to think that this is my act which may affect any particular person. Now, another judge examined previous cases and held that the law takes no cognizance of the carelessness in the abstract. He is saying that if there is no particular law, there is no contract, then there is no cognizance. It concerns itself with the carelessness only where there is a duty to take care. If there is no duty to take care or to act in such a manner, then there is no liability, and where failure in that duty has caused damage. So in this case, we will have to observe whether the manufacturer had the duty of care towards the consumer or not. So this judge observes that whether there was a duty of care. He further held that according to this standard, Stevenson has demonstrated carelessness by leaving bottles where snails could access them. So according to him, manufacturers have duty of care towards the consumers because they can foresee that this product will be consumed by them, and if there is some duty of care, then they will have to comply with that. That he owed Donoghue a duty of care as commercial manufacturer of the food and drink, and that Donoghue's injury was reasonably foreseeable. If you are not acting in a manner in which you have to, then it can be reasonably foreseeable that if something went wrong, if something goes wrong, then the consumer will be affected by that. He therefore found that Donoghue had a cause of action. He can file a case and he can claim damages from Stevenson. So the outcome of Donoghue versus Stevenson established legal principles like negligence, so that if you are acting negligently, then you will be responsible for that. Duty of care, to whom we owe duty of care, and very important principle of neighbor in this case. So in end, the appellant's claim was successful, that is Donoghue's claim was successful. This case established the modern law of negligence, and the neighbor test. That is, people must take reasonable care not to injure others who could forcibly be affected by their action or inaction. So whoever can get affected by your action or inaction, that particular person will be termed as neighbor, and you will have to, while doing any particular act, you will have to foresee that who may get affected and should not act in such a manner. So students, this is all with respect to Donoghue versus Stevenson case, in which there was a snail, decomposed snail in the ginger beer, and after consuming that, the person who consumed it falls sick, and he claimed damages from the manufacturer. As at that point of time, the damages can only be claimed if there is any contract of sale, but a new principle of negligence explained and duty of care and neighbor was well explained in this principle that is still relevant in today's world. So thank you very much for watching this video. Stay tuned for many more informative sessions like this. Thank you.